The court is ready to hear argument in 19-658, Texas Department of Transportation against Lara from Travis County and the Third Court of Appeals District.
May it please the court, Ms. Klusman will present argument for petitioner. Petitioner has reserved 5 minutes for rebuttal.
Thank you. May it please the court. Lara does not have a viable claim when considered against the text of the TCHRA and relevant precedent. A reasonable accommodation enables an employee to perform a job. 6 months of leave does not. Protected activity requires an employee to identify and oppose discriminatory practices. Merely requesting leave doesn't do that. TxDOT did not violate the TCHRA when it ended Lara's employment. The court should reverse the third court's reasonable accommodation ruling, but otherwise affirm its judgment. I'll begin with the reasonable accommodation claim. So our text is from 21-128A of the Labor Code, which requires employers to make reasonable accommodations to an otherwise qualified individual with a disability. So from this, we get the principle, of course, that the individual must be qualified. And case law uniformly says that to be qualified, you must be able to perform the essential functions of the job with or without a reasonable accommodation. So the flip side of this is also true. An employee is not qualified if there is no reasonable accommodation that would enable that employee to perform the essential functions of his job. So the question in this case is, what do we do when leave is the requested reasonable accommodation? And so, excuse me, if you look at all the cases that we cited, there are no bright line rules, but the court can still find on the basis of the facts in this case that the 6 months of leave requested by Lara to overcome the disability that he had is not a reasonable accommodation.
Would you look at the entirety of the leave that, or would you look at the 5 weeks that were at issue to allow him to, Mr. Lara, to become able to perform the functions of his job?
I would look at all 6 months that was necessary, Your Honor, because that was the entirety of the accommodation that he needed. Thought of in a different way, if we only look at what was left, he needed 5 more weeks. That would encourage employees simply to ask for leave in short increments. And that way they could always say, well, I only needed 2 more weeks, and you can't consider all the leave that you've given me in the past. One other way to think about it is if he had said from day one, I'm going to need 6 months of leave, and TxDOT said, well, we can give you 4.5 months, the extent of the sick leave pool, we'd be the exact same circumstance. So I don't think it matters whether he requests his leave in increments in that sense. It's still going to be a total of 6 months at the end of the day.
But TxDOT didn't say that. They also had a policy that about leave without pay that he was entitled to take advantage of. So how does that factor into the analysis?
Your Honor, I don't believe it really impacts whether or not he was qualified to perform his job. The policy itself says we will give you leave if it's necessary for a reasonable accommodation. So we still first have to answer that question. Was this a reasonable accommodation in the first place?
Well, when would it be?
I'm sorry, Your Honor. When would it be? When would 6 months or 6 months, I don't think is going to almost never be a reasonable accommodation of leave.
You have it in the policy. I don't understand.
I'm sorry, Your Honor, I couldn't hear that.
No. TxDOT has a policy. If it's never going to be reasonable, why do you have a policy that it could be extended?
Well, sorry, suppose he needed leave without pay from the very beginning. So there could have been several months when leave without pay could have been appropriate as a reasonable accommodation. And if this, there could be, I guess, extenuating circumstances where a reasonable accommodation would be 12 months of leave. I'm not quite sure that would happen, but it's, I guess, a possibility out there if you look at some of the federal courts. But I think if you look at the facts of this case, where he needed 6 months off, he had daily duties that needed to be attended to. His job was not seasonal, such that these were the off months where he didn't have many obligations, and that other employees were having to cover for him. This is not.
Doesn't that go to undue hardship, though? And I think the chief was asking about the accommodation that TxDOT has in its own policy about up to a year of leave in the supervisor's discretion. And how does that fit with your argument that less than a year is, a request for less than a year is unreasonable.
Well, I guess I would say that, I guess, two parts. First of all, yes, and a lot of the impact on TxDOT is part of that undue hardship consideration, but some of the federal courts also consider the impact on other employees when deciding whether or not a given accommodation is reasonable. So here, there was an impact on other employees. But to your other question, a leave policy is a leave policy. It is not the law. And so whether or not leave is required under the TCHRA is a separate question from whether or not TxDOT would otherwise grant it. It doesn't answer the question whether or not he is qualified to perform the essential functions of his job at the time of his termination. And so in this circumstance, he simply was not. And we see from multiple federal courts that multi-month leave or leave of or extended absences are often not considered reasonable accommodations because it essentially excuses an employee's ability to perform his job rather than enabling him to perform his job. Now, the 10th Circuit,
Here, Ms. Closman, here wouldn't the additional time off, the initial leave actually enable him to do the job? He's receiving time off from medical treatment to perform essential job functions. And isn't that consistent with the ADA as well? Thinking about, a qualified individual that way?
Well, if the only question is whether leave would ultimately result in an employee being able to perform his job, then no amount of leave is ever going to be unreasonable. You could say, I need 2 years off in order to recover. And that's going to, under that theory, be a reasonable accommodation because at the end of the time, you would be able to perform your job.
And
now,
how do courts draw those lines? I think you were about to answer that, but I want to ask you to answer that in light of the policy that you have internally on the leave without pay.
Sure. I was going to say that the 10th Circuit in Huang identified 3 factors that it was looking at in deciding whether or not, leave of a small amount became unreasonable the longer it lasted. And so it looked at the duties essential to the job in question, the nature and length of the leave sought, and the impact on fellow employees. And so again, here we've got 6 months. There was discretion under the policy to grant, up to 12 months, but that was just discretion. And a supervisor can look, as they did in this case, and say, this isn't working anymore. We're having to pull too many employees in. So unless leave was necessarily a reasonable accommodation, the policy leaves it to the employer's discretion. And that discretion was exercised here to conclude that they needed to replace Lara at that time.
Ms. Closman, whenever you say that anybody could take that much time, a year or 2 year, whatever, doesn't it all depend upon what a medical professional is saying? And that's what happened here?
Well, that certainly would be, I think the employee would have to demonstrate that he was disabled for that entire period of time. But again, if he is disabled for that entire period of time, he's not able to perform his job. I would point the court to Texas Labor Code 21105, which concerns disability discrimination, which is closely related to this failure to accommodate claim. And there, the legislature has explicitly limited disability discrimination to to conditions that do not impair an individual's ability to reasonably perform a job.
But in line with Justice Guzman's question, it wasn't just for an extended period of time. It was to enable him to come back to work, to accommodate him so that he could prepare himself to come back to work for the period of time that the doctor said was necessary, or the medical professional.
Yes, but during those 6 months, he was not qualified. At the time that he was terminated, he could not perform any of the essential functions of his job. And so that's what we're looking at here, not whether or not at some unknown point in the future, or even if we assume that he could have come back in October, at that point in the future, he may have been able to do it. But as the 7th Circuit and the 10th in Severson and the 10th Circuit in Huang pointed out, reasonable accommodations are designed to enable an employee to perform his job in that moment. And so simply saying, well, several months from now, I might be able to do this, is really giving those employees an unfair advantage by saying, well, we're just going to have to hold your job for 6 months when you might not hold it for anyone else for that period of time. So
is your argument that, are you arguing that not working or taking leave can never be a reasonable accommodation because it doesn't enable you to perform the work? Or are you arguing that it can sometimes be a reasonable accommodation, it's just not the case here?
The second option, Your Honor. Leave can certainly be a reasonable accommodation for, I think the Seventh Circuit identified sort of intermittent conditions where you need a day or two off here or there, maybe a week every once in a while. I think of it as sort of a normal employment process where people take 2 weeks of vacation or they're off for a week when they're sick. That kind of leave, employers deal with that. They absorb that, employees cover for each other. But when you start making that leave longer, you've left what is normal and are now at 6 months entering what is really an abnormal situation where an employee can't work at all. And so in the facts of this case, that much leave would be unreasonable.
Ms. Klusman, is that a jury question?
Only if this court says so, but multiple courts, I would say most of the cases that we cite in our brief, they treat this as a summary judgment question. So the burden of proof is on Lara to demonstrate that leave is a reasonable accommodation on the facts of this case. And our submission is that on the facts of this case, it is not reasonable to grant 6 months of leave. I do want
in
to
the
touch-
Wong case, Kansas law and the employer both had a 6-month leave policy. So is there a case where the employer has a 1-year policy that a court has said that an employee that's inside of that 1 year doesn't raise a fact issue on accommodation?
None is coming to mind right now. Most of the cases, I think they talk about, you've served off your FM, like for example, the Severson case, he'd served his FMLA time and then needed another 2 to 3 months after that. And the court said that was too long. So that's the closest I can come right now. But that's what I remember from all of the cases that we've cited.
Ms. Klusman, you just indicated under the facts of this case, 6 months is not reasonable. Are there any scenarios under the current framework that would make 6 months or more reasonable in your view, understanding that you contend it is not so here?
I think it would have to be a fairly unusual job. The best I could come up with was if you were involved in a professional sport of some sort where you've got 6 months of downtime in between the season. The example that the court gave in Huang was of an accountant right after tax day, where he doesn't have as much work, maybe 2 months of leave there would be appropriate because it is sort of a seasonal job. And so if we're talking about months of leave like this, I think I would look for examples that are, sort of a seasonal position where you do have multiple months of downtime when your leave would have less impact and you have fewer essential duties perhaps to do during that time. I do want to quickly touch on retaliation. The text relevant here is whether or not Lara opposed the discriminatory practice. And his argument is that merely requesting a reasonable accommodation is opposing a discriminatory practice. And this court has never interpreted the language that way. Instead, it says that the employee must voice opposition to conduct made unlawful under the TCHRA or to put the employer on notice that the employee believes there is discriminatory conduct going on. And so simply submitting leave forms, as Lara claims he did in this case, leave forms prepared by TxDOT does not notify TxDOT that he believes TxDOT has violated the law in any way. Same thing for calling and asking questions about what he needed to do to keep his job or, how does he go about requesting leave? Those kinds of things don't put TxDOT on notice that he believes they are violating the law. And indeed, TxDOT hadn't been violating the law. It granted him all of the leave that he requested up until September. So until that moment in September, when he found out he would not be getting any more leave, there was no discriminatory practice to oppose. So he could not, in fact, have been terminated in retaliation for opposing a discriminatory practice when there was nothing prior to his termination that he could have opposed. So I believe that'll probably be it. I'm about out of time. So for the reasons stated, 6 months of leave is unreasonable in this circumstance. He had daily duties that needed to be handled. and other people were having to cover for him. And so just in the nature of his job, 6 months is going to be too long. And he did not make a report of discriminatory conduct. He didn't oppose anything. And so his retaliation claim should also fail. So we ask that this court would, again, reverse the reasonable accommodation ruling, but otherwise affirm the third court's judgment.
Any other questions? Thank you, Ms. Klusman.
Thank you.
We'll hear from the respondent.
May it please the court, Mr. Talbot will present argument for respondent.
Good morning, and may it please the court. This case presents the opportunity to address and affirm two important issues of Texas employment law. And the first is that leave is a reasonable accommodation. And you've heard TxDOT acknowledge that here today. And the second is that an employee's request for a reasonable accommodation is protected activity under Texas retaliation statute. Now here, following his surgery, Mr. Lara pressed his supervisors for leave so that he could heal and return to his job. TxDOT has a mandatory leave without pay policy, granting employees like Lara up to 12 months leave without pay. And yet on September 16th, TxDOT denied Mr. Lara's request for just 5 weeks leave without pay and fired the longtime employee.
Do you think TxDOT can exercise its discretion in determining, the parameters of that leave? For example, the argument is that here that's too much because of the nature of his job, where somebody else, a different type of job, maybe 12 months would be appropriate. And how does that factor into the analysis, the fact that it's discretionary?
And I'm going to push back against TxDOT's characterization that this is discretionary. I'd invite the court to look to tab 3 of the bench book, which is TxDOT's own policies. And it says that supervisors must grant leave without pay where necessary for employees with a disability. You've not heard TxDOT argue that Mr. Lara didn't have a disability. To the contrary, Brad Powell testifies on 374 of the record, yeah, Mr. Lara had a disability. But getting to your earlier question, Justice Guzman, you asked, what is the relevant time period? Are we looking at 6 months or are we looking at 5 weeks? And you heard TxDOT say 6 months. That's not right. Again, the ADA's, the EEOC's regulations at 29 CFR 1630, the appendix says the relevant time to determine qualifications is at the time of the employment decision. That was September 1st or that was September 16th. We know that's true because the Fifth Circuit told us that in Dillard v. City of Austin in 2016. And it noted just because an employee has run through a policy that provides leave or FMLA leave doesn't absolve the employer from complying with the ADA. To the contrary, they still have a present and future obligation to do so. And so the question for this court is, was Mr. Lara's request for 5 weeks leave without pay reasonable on its face? And picking up a thread from Justice Hecht, that's a jury question where you have policies that allow up to 12 months and the employee needed just a fraction of that, that is certainly something that should go to a jury and a jury should decide. Now, you've heard TxDOT say that they don't adopt a bright line standard, that this court can't just say as a matter of law certain periods are unreasonable. Well, that's correct, because we know that the ADA is all about a flexible, fact-specific, individualized inquiry. And so what we have in this case was Mr. Lara's healthcare provider indicated on October 21st, he could return to work. What we know is that Mr. Lara's sick leave pay ran out on September 16th. What we know is that TxDOT's own policies recognize leave without pay as a reasonable accommodation. TxDOT's own policies recognize up to 12 months as a reasonable accommodation. Justice Bland, I think you asked a question about, well, do we have situations of a more generous leave policies? And I think the 10th Circuit in Rascon did a very good job of hammering that issue. And what it noted was the employer there had these very generous leave policies. And what the employee needed was just a fraction, was less accommodating than what the employee required. The same holds true here. And so let's keep in mind as we walk through this inquiry, this is mirroring an MSJ.
So are you saying that the employer's policy is going to mirror their legal obligation? If an employer decides to be more generous than other employers in providing opportunities for leave, that's going to become then the floor of their legal obligation to the employee, as opposed to something more concrete outside of the employer's policy?
The employer's policies do not set the legal standard. They do, however, inform the reasonableness analysis. And we see this time and time again in Rascon and Sayers and Hall. And I'd note, just because in this case it is generous does not mean that employers don't often avail themselves of their own policies. You remember in U.S. Airways v. Barnett, the Supreme Court of the United States said, look, the employer has a policy not to move people in a certain way, and we're going to acknowledge that. And so informing that reasonableness analysis, the jury can and should consider those reasonable policies. We've noted here that really the issue is about reasonableness. Is this request reasonable on its face? And there was a question about undue hardship versus reasonableness. And I just want to make sure that we're clear. Those are distinct analyses, that an employee's initial burden is merely to show that the request is reasonable on its face. After that, an employer can then show that the otherwise reasonable accommodation nonetheless creates an undue hardship. And
if it had been 10 weeks instead of 5, would that be unreasonable? And how would we make that determination given the mandatory nature of the policy that you've argued?
I do not think that 10 weeks would be unreasonable either. I think there certainly is a point in which an employee would exceed what was reasonable. 10 weeks was not that. Mr. Lara's 5-week request was reasonable. And as far as what this court should consider in trying to draw that line, the legislature has told us this is a reasonableness inquiry. It is a question about these circumstances for this employee and what this employer can manage, and whether or not the employee can show that it's reasonable on its face. And so,
Mr. Talbert, if we are taking a look at the whole big picture in terms of reasonableness, don't we, in order to consider reasonableness for the employer, have to consider the fact that this wasn't a 5-week time period, but multiple months? Help me understand why you're focused on why you think the clock starts ticking at the 5-week mark. And is it that because when the leave without pay started, as opposed to other kinds of pay, other kinds of absence?
Sure. And so Mr. Lara made use of FMLA and both sick leave pool benefits to extend his leave to September 16th. Then he needed just that 5 weeks of leave without pay. And so a court certainly is mindful of that and considers how much leave was necessary in all. But what we know is that Lara required just that 5 weeks of leave without pay. And so what the court should consider to answer this court's question is what TxDOT itself has acknowledged as reasonable. They've acknowledged that as a reasonable accommodation, leave without pay is sometimes required. And you see Lance Simmons, the decision maker, acknowledge this. He says, look, leave without pay is mandatory. You see TxDOT acknowledge that up to 12 months is reasonable. And so really the question for this court is, on this record, is there some evidence on which a reasonable jury could conclude that this was a request for a reasonable accommodation, that TxDOT failed to make that accommodation and fired Lara instead? I think the answer there is absolutely. And that's consistent with the ADA. That's consistent with a wealth of authority. And you heard two cases. You heard Huang from the 10th Circuit and the 7th Circuit authority. Justice Bland, I think it was you that noted there was a maximum leave policy in Huang of 6 months of Kansas State and under state law. Contrary to that, you have a leave policy of 12 months here. And so you remember what Judge Gorsuch, now Justice Gorsuch, noted in that opinion, and TxDOT's attorney acknowledged this as well. This is a fact-specific inquiry. He said what may be reasonable for, say, an on-call emergency medical provider may look a whole lot different than a tax preparer after April 15th. So too here.
For this circumstance then, in Mr. Lara's case, since we're starting the 12-month mandatory leave policy clock running in September, it's your position then that it would have been reasonable and mandatory for him to have approved leave without pay through the following September, then to total 18 months of leave.
I think we're probably getting close to the border of reasonableness there, certainly. If we've got an employee taking 12 months, 18 months, that certainly is coming to the edge of reasonableness. My submission to the court today is that on 5 weeks request for leave, there is certainly a fact issue on this point. I will turn to the retaliation issue, and that is that Mr. Lara has pled and proved a viable claim for retaliation. Now, under Texas Labor Code 21.055, an employee needs to show that he engaged in protected activity. He suffered an adverse employment action, and that there was a causal connection between the two. And really the brunt of the analysis in the briefing you saw focused on this first element. Did Mr. Lara engage in protected activity? And the answer is yes, that Mr. Lara constantly calling, pressing, asking for reasonable accommodations was protected activity for three big reasons. And the first is there's virtual uniformity on this point under federal law, EEOC guidance, and Texas state law. The second is that it fits within the text of Texas retaliation statute. And third and finally is that it makes for good law. It brings uniformity to this area of law. And so turning to the first of these, we see across the board, every single federal circuit has held that an employee's request for accommodation is protected activity. We see the EEOC guidance, which we included at tab 2 of our bench book, echoes this conclusion. A request for accommodation is protected activity under retaliation statutes. We see Texas law, 3 different Texas courts, 4 different holdings, all of which acknowledge Rockwood, Birch, Haygood, Quinn, that a leave request, a request for a reasonable accommodation is protected activity. And here's what those courts recognize, that makes sense. As the United States Supreme Court has told us, under Title VII, a similar retaliation statute, the purpose of these retaliation statutes is to provide unfettered access to remedial mechanisms, meaning that it needs to provide a clear ability for an employee to access rights guaranteed by statute. To tell employees that anytime they ask for an accommodation, they are putting their job on the line, undercuts the ability to even ask. And here's what it comes down to, that absent protection from retaliation, there is no right to seek an accommodation. These are two sides of the same coin. That if an employer's request is not protected, then we've negated the ability to even ask. And that's what you see courts construing analogous provisions under the ADA and under Title VII. And that kind of brings us to the plain text issue. Remember, Texas's Labor Code 21.055 mirrors, or it looks a whole lot like the ADA provision 12203A. Both of them make it protected activity to oppose an unlawful employment practice. What happened here and where the lower court went awry on its analysis was concluding that 12203, a slightly larger section under the federal ADA, that because it doesn't exist in Texas's statute, that we can't conclude that opposition is protected activity here. But again, we know that courts rely on 12203A, opposition language, to conclude that this is a request for a reasonable accommodation. We saw the first circuit.
Mr. Talbert, in what sense is requesting a reasonable accommodation opposing a discriminatory practice?
And I think the Supreme Court of the United States has given us some pretty good guidance to answer that question. And it does two things. Remember in Crawford in 2009, under the Title VII opposition language, although that was not a request for accommodation, and I acknowledge that, it says two things. We're going to skew, or we're going to read opposition broadly in favor of employee protections. And the second thing it tells us is that in giving that term opposition its plain meaning, it can mean to correct, to prevent, to resist, to end, to redress. And so the question is, where an employee says, I believe I am entitled to this accommodation, that inherent in that is the attempt to correct, to prevent, to resist, to end, to redress, something the employee believes that he is entitled to, and the denial of which would be wrong. And so the facts here, to address that question, Justice Busby, show that Mr. Lara testifies in his deposition that he believed he was entitled to leave. He says, I thought I was entitled to it. I thought I was doing everything I could. He testifies when he's questioned by TxDOT's attorneys, he thought it was an unlawful employment practice when TxDOT denied that request. And what he does is he is constantly calling. He is texting. He is faxing. He is talking in person. He is sending his wife up there with paperwork, doing anything he can to make sure he gets leave without pay. And so I think that there is an outcome here where the court should certainly that the court should find that a request for an accommodation is protected activity. But I would note this, that there is an outcome here where the court saves that question for another day and could conclude that on this record, constantly calling, pressing, all of this conduct certainly rises to the level to create a fact issue that there was opposition to a discriminatory practice. And the last thing we noted here was that this makes for good law. It ensures that Texans enjoy the same rights, remedies, and protections as under their counterpart. To hold to the contrary and accept TxDOT's position signals to the rest of the country that Texas workers enjoy less protections than anywhere else. And that doesn't make for good law, and that doesn't make sense. You know, the final element of this retaliation claim that's in dispute is the causal connection. Remember, there must be a protected activity. There must be an adverse employment action, no dispute there. And there has to be a causal connection between the two. And we've presented evidence of just that. And this court in the Fifth Circuit has told us that there are certain indicators or indicia of retaliation or discriminatory intent. That includes violation of a company's own policies. That includes close timing. That includes shifting or inconsistent explanations. That includes knowledge by the decision maker. Every single one of those is present in this case. When we turn to the first of those, violation of the company's own policies, TxDOT's policy, again, mandatory leave. 396 of the record, Lance Simmons, the decision maker who made the decision to fire Lara, you see him grappling with his text. He says, must does mean mandatory. He testified at 396, I considered that leave policy before I fired Lara. The very next page, Lance Simmons testifies, oh, we also have a policy to reach out and to initiate this conversation for employees. He says, I considered that too, and I fired him anyways. We have a clear-cut violation of policies here. And we've noted
Does your position that violation of the company policy equal a violation under the ADA incentivize employers to limit their leave policies to only leave that's required to be permitted under state or federal law? In other words, there's two standards, one for employers that limit leave to only that's legally required, and a different standard for employers that allow longer leave periods. And in the latter category, even if they've allowed longer leave than that required by law, they are still subject to liability under the ADA. Does that create disincentives to employers to offer generous leave benefits?
And I'll answer that in two parts. And the concern here, and I hear it, is we don't want to punish employers who've offered generous leave policies. And I think that there are built-in safeguards to prevent or protect against just that. And the fact is that often, as I noted earlier, companies have policies that sometimes are used to avail and protect the employer, kind of like US Airways v. Barnett, and sometimes they're more employer friendly. And so does that set the standard of care? No, it doesn't. Does it inform the reasonableness analysis, and can it present evidence of pretext of retaliation? Yes, certainly. And the second issue addressing that concern, Justice Bland, is remember, whether there are policies or whether there are no policies, this will always be a fact-specific inquiry. And so there could be situations where no policies exist. Certainly, we've seen that in Haygood v. El Paso, where the employer dispatched their obligations. They did what they needed to. They accommodated the employer. And so the employee, I don't think that you're going to see employers drastically reduce or slash their policies to prevent against this, because it is always part of an ongoing reciprocal dialogue. And that's what should have occurred here. And instead, what we know is that Lara requested leave on August 18th, and just 2 weeks later, they made that decision to fire him. And this is kind of where the lower court's analysis goes awry. They noted that, well, he asked for leave in May, but they didn't fire him until September 1st, and that's just too long. But remember, the obligation is triggered every time the employee asks. He asked just 2 weeks before Lance Simmons made the decision to terminate him. And that's what it gets down to, is that under Texas law, that on this evidence, where Mr. Lara is constantly calling, pressing for accommodations, texting, faxing, asking in person, that he engaged in protected activity, and that there is a causal connection between his request and the denial of what he sought. And so,
going back to reasonable accommodation, and I don't know that this has any relevance, frankly, to how we interpret the statute, but it seems to me that your position sort of turns on its head the normal considerations that an employer would have in mind with respect to which employees it's going to keep around. I mean, if the position is, well, it didn't matter very much whether I was at work doing my job, if that's a reason I get to keep my job, it's a little odd. And then the employee who was essential, who really needed to be there, doesn't get to keep his job if the request is leave without pay, whereas the employee who doesn't need to be there is entitled to stay on the payroll. It's an odd result from the perspective of an employer who's trying to be judicious with resources.
And Justice Blacklock, I think the law provides a remedy and a safeguard for exactly that concern. Remember, an employer can always show that it created an undue hardship, that they just couldn't get along without this particular employee. Again, that would be TxDOT's burden. And what
But your argument is if you can get along without me, you have to keep me.
That is not necessarily our argument to the court. Our argument to the court is that it is a question of reasonableness, how long an employee could be out. And so there are certainly some employers and some situations that lend themselves to a more expansive leave policy, certainly. I see my time has drawn to a close. Thank you.
Any other questions? Thank you, Mr. Talbert. Ms. Klusman, I believe you have 5 minutes.
There, I think I'm unmuted now. I would like to touch a few points on retaliation before turning back to reasonable accommodation. First of all, this court in San Antonio Water Systems versus Nicholas said that the employee must have a reasonable good faith belief that the employer has violated the TCHRA. I didn't hear that. I didn't hear what TxDOT allegedly did that violated the TCHRA up until the moment that it ended his employment without granting him leave without pay. He didn't protest that.
Ms. Klusman, why isn't that a jury issue, the issue of reasonableness? What is your answer to that argument?
Because, Your Honor, the facts do not raise a question of fact on reasonableness. In these facts, under these facts, 6 months is too long. If we look, I think a lot of people have been focusing on this policy, the leave policy for TxDOT. It specifically says that directors may grant leave without pay at their discretion unless it is required as a reasonable accommodation for disability. So
I mean, I think it says it's mandatory if it's reasonable. And so how can 6 months be something that would not be submitted to a jury because there's no fact issue as a matter of law?
But you first have to decide whether or not 6 months is reasonable before the policy is even relevant. The policy doesn't kick in until we first determined that it would be reasonable to give you 6 months, and then the policy kicks in. So it's really sort of irrelevant until we get to that undue hardship defense, because then if TxDOT comes back and says, well, 6 months is if you say 6 months is reasonable and TxDOT wants to then come back and say it's an undue hardship, you point to this policy. But you first, without the policy, have to decide whether or not 6 months is reasonable. And it's simply not in these circumstances. Sorry,
Chief Justice Rose, Ms. Klusman, Chief Justice Rose thought that the request amounted to indefinite leave because he wasn't able to return to work at that time and he was still having medical treatment. And do you think the request amounted to indefinite leave?
I think that is a reasonable, yes, I do. I'll put it shortly. He had twice extended his leave without explanation. Even the documents that he submitted in July, the leave form says he can come back on October 21st, whereas the FMLA form said he was going to be incapacitated until November. And it also indicated he would need future leave to have a colostomy takedown. So those are, go ahead. I was just going to say, those are, if we're considering all of the facts, those are also facts that that TxDOT is going to consider. In addition to the length, it just kept extending itself out, and he was probably going to need leave in the future. So,
so I just wanted to ask you about this. Maybe I don't know if it came up in discovery, but I keep hearing you argue under the facts of this case, under the facts of this case. To what extent do, during the discovery process or at trial, would an inquiry into similarly situated employees become relevant? In other words, this is Mr. Lara and you all chose to fire him. What if Mr. Smith, is there a Mr. Smith out there under the same circumstances that didn't get fired even though he had requested, 6 months leave? So does that become relevant at any point?
I think that would be relevant under the undue hardship argument if TxDOT was going to say we just can't give anyone 6 months of leave And you pointed to, well, you actually have done that in the past. I think that would fit there. Also, if you were bringing a retaliation or disability discrimination claim under the pretext analysis, I think it might fit there as well. But I would point the court to the Fourth Circuit's opinion in Myers versus Hose. And there they just have a really good discussion about how employers are entitled to be generous without binding themselves legally to continue that generosity indefinitely into the future. And I think Justice Bland's questions kind of touched on this a little bit, but we want employers to be generous. We want them to have leave policies, but that's different than what they are legally obligated to do under the TCHRA. And so, I mean, theoretically, under I guess, Mr. Lara's theory, as long as he just kept asking for small bits, he could build up enough generosity at TxDOT to say, well, now you just have to keep granting me leave in the future because you've granted me so much in the past. And the federal courts just haven't required that as a general matter, at least from the cases in our brief. So for those reasons, Your Honor, we ask that the court would reverse the reasonable accommodation ruling, but otherwise affirm the third court's judgment.
Any other questions? Thank you, Ms. Klusman. The case is submitted and the clerk will adjourn the court.
Oh, yay, oh, yay, oh, yay. The Honorable, the Supreme Court of Texas now stands adjourned.